Yes.
May I please, my lord. My lord, I would like to withdraw item number 2.
Want to withdraw it?
Yes, with liberty to file press because the wrong section has been inserted. Item number 2.
Your
L. Kagum.
Direct Counsel Mr. L. Kagun, appearing for the petitioner submits that there are some typing mistakes in the application. Therefore, he wants to withdraw this application. Mr. Kagun submits that he will file the same application with corrected sections of law. I have heard Mr. J. saying the learned public prosecutor for the State Board of Appeals. Application stands disposed of withdrawn.
Much obliged.
Interim order pending.
No, it's
Interim order pending.
no, today is for motion.
Oh, it's not in motion.
Much obliged.
Yes.
Yes. Lordship, there's one petition. There are 3 petitions stacked together, my lord. These were listed on 3rd of September, but Justice Ite cannot take up it was informed on that day that he cannot take up the matter because earlier he was involved in as a counsel. My lord, may I pray, but no date has been fixed because since Lordship has recused. May I pray that the matter could be taken up today just for fixing a date, my lord? Today, my lord, just for fixing a date for orders, my lord.
Yes.
Your Lordship, I'd like to mention item number 26.
Item number
26. The leading counsel for the respondent is going through medical treatment in his hometown.
26.
26.
Who is absent?
The respondent, Your Lordship. The leading counsel for the respondent.
Ikipangi.
No. Subu Koyang.
Huh?
S. Koyang.
Item number
6.
26. Oh, S. Koyang. He is absent.
Yes, Your Lordship.
Have you informed the appellant?
Yes.
The learned counsel MS, what is your name?
Radhayakang.
Appearing on behalf of the respondent submits that the learned conducting counsel, Mr. S. Kayang, is not available today and on the ground an adjournment has been prayed for.
Your Lordship, this matter may be fixed on 23rd of this month.
The prayer for adjournment is allowed, list on 23rd.
Much obliged.
23rd.
May I please, Your Lordship? Your Lordship, I beg to mention item number 20, Srimati Anu Talang Pangdo versus State of AP and Anana.
20.
Yes, Your Lordship.
You are for the
Appellant.
appellant.
Yes, Your Lordship, and I have also taken a consent from PP.
Okay. What do you want now? What do you want?
Your Lordship, this matter may be fixed after 1 week.
After 1 week.
Yes, Your Lordship.
What is your name?
K. Basar.
The learned counsel MSK.
Basar.
Basar, appearing on behalf of the appellant.
Yes, Your Lordship.
So who is your senior?
Mr. K. Posi.
Appearing on behalf of the appellant submits that the learned conducting counsel, Mr. K. Posi, is not available today and on the ground an adjournment has been prayed for. The prayer for adjournment is allowed least next week.
Much obliged.
Your Lordship, I would like to mention item number 27.
27.
Yes, Your Lordship. I'm appearing for the respondent number 2. Appearing on behalf of learned counsel, Mr. P. Tamin. Praying for adjournment, Your Honor. I have taken the consent of the other counsels as well.
Have you informed the other side?
Yes, Your Lordship.
The learned counsel, Mr. What is your name?
M. Tangzang.
Appearing on behalf of the learned conducting counsel, Mr. P. Tamin submits that Mr. Tamin is not available today and on the ground an adjournment has been paid for. So the learned counsel further submits that he has already informed the other side. According to the hearing is adjourned today, least after 2 weeks for hearing.
Much obliged.
Yes.
I beg to mention an interlocutory application which is filed in connection with a writ petition relating to transfer of service.
Next Monday.
Yeah.
Your Lordship, I beg to mention item number 7 on behalf of BK Misra.
Item number 7.
7. Your Lordship, I have been informed that he is not available today, having some personal difficulties. So, matter may be fixed after 2 weeks.
The Learned Counsel, Mr.
J. Karbak, on behalf of BK Misra.
Behalf of Mr. P.K. Mishra. Submits that Mr. Mishra is not available today.
Can a fixed date be given, my lord, on
Grounded ground and adjournment.
20
I have also heard Mr. T. Party.
25th, my lord, then in that
Huh?
case,
5th.
25th.
Appearing on behalf of the opposite party. The case is adjourned today, released on 25 September.
Much obliged.
My lord, mention item number 11. Item number 11. G, yes.
Criminal petition. You are for the petitioner.
Respondent number 2,
You are for the respondent.
yes.
What do you want?
My senior is
Your senior is,
currently not available.
who is your senior?
Yes.
Who is your senior?
R. Raksap,
R. Akshap,
yes.
the Learned Counsel, Mr. What is your name? Your name,
P. Padu,
appearing on behalf of Mr. R. Akshap, the Learned Counsel for the respondent. Comma submits that Mr. Akshap is not available today and on the ground and adjournment has been prayed for. The prayer for adjournment to the Lord. List next week.
My lord, I'd like to mention one item for tomorrow, madam.
What is the item?
My lord, this is criminal petition, madam.
Huh?
Criminal petition.
Criminal petition.
Yes, my lord. It's all matter, madam. God bless.
Yes.
May I please? My lord, this is a criminal revision petition, my lord. My lord, here petitioner is selling interim order dated 8/8/2024. I wish, my lord, one of the accused person, my lord, has been discharged, my lord, who has been number 2.
You are against the discharge order.
Discharge of, my lord, private respondent number 2, my lord. Because, my lord, the learned trial court has considered only the 161 statement of the one of the witness only, my lord. They two not been properly not considered, my lord. There are, my lord, other witnesses also, my lord. Now the learned trial court is saying, my lord, that there is nothing on the record to say that she threatened or she intimated or something like that. But other witness 161 statement, my lord, it discloses, my lord, that the deceased person, my lord, who was murdered, the victim, my lord, she telephonically called her uncle just before her death, my lord, saying that this private respondent number 2, my lord, she's threatening me. She's asking me to vacate the home. It's for the private property, my lord.
Is it a case of suicide?
No, my lord. Murder, my lord. So far here, my lord, husband of the private respondent number 1, my lord, and the son, they both have been charged, have been framed against them, my lord. So far, this particular respondent number 2, she has been discharged. Otherwise, my lord, she is the main person, my lord. Because everything happened out of her involvement only, my lord. May I take, my lord, so my lord, at this stage, otherwise, my lord, only notice is to be issued, my lord. And matter needs to be examined, my lord.
Heard Mr. R. Sonar, preparing for the petition. Heard Mr. J. saying, the Lord Public Prosecutor for the State of Arunachal Pradesh. Issue notice. No formal notice is required to be sent to respondent number 1, as because Mr. Saying has accepted notice. Extra copy of the petition shall be provided to him. The petitioner shall take steps for service of notice of the respondent number 2 by registered posted AD. Do you want any interim or
No, my lord.
least after 4 weeks?
No, my lord.
Yes.
May your lordship, this is a question petition to quash the Bandadeo PS case number 01/2017 and GR number 68/2017. And this petition is being moved by for petitioner that petitioner number 1 is a backhaul order operator. So the fact of the case is that in the year 2017, there was one government sanctioned road project. Based on that, this backhaul order operator was hired by that department contractor. And based on that department contractor, that backhaul order operator has widened that colony road, one village road. That village is there nearby in Bandadeva. So subsequently, after that completion of that road has been sanctioned under government project. That's in page number 23 to 24. That based on that survey report, that's page number 23. Lordship, that's page number 23. In second paragraph, in second para, the further government of Arunachal Pradesh sanctioned a road project in the southern corner Assam side of Nefa Udyog to connect Dolikoto village with government sanction order number SUD under SADA PLG 474 2016-17 dated 13 February 2017. So for the BS of this to widen that road, they were cutting that road, and subsequently that road is being used, and that present road map is there in page number 35. It can be seen visible in page number 35. Page number 35, that the yellow mark is the compound of that informant who has informed that there is a criminal trespass in their compound. But since this, it can be seen that road is clear, that sideline of that boundary, that road is there. So that road has been sanctioned by the government, and this that land has one of these informant land is being allotted by the government of Arunachal Pradesh with the allotment number to one Nefa Udyog for the purpose of timber industry. But right now that is not being used by them as a timber industry, but it's a government land. So during this meantime, that in government land only, that government only, they sanction that road only for 3 to 4 meter wide and 100 meter land. So for the approach road till motorable road till the villagers, and backside that the villagers, all that village settlement. So during this period, what happened, this petitioner number 1, being a backhaul order operator, there was one information given to the manager of this Nefa Udyog that there is land encroachment. And based on that, just for the cognizance, they had reflected section 447. And that's 447 is punishable only 3 months and fine of ₹500 only. Just for the sake of cognizance of that cognizable offense, that case has been registered. And meanwhile, subsequently, this matter has been put up before this Honorable Learned Chief Judicial Magistrate UPR. And even in 2018, that's in page number 45, for Lok Adalat settlement. Twice, that this was a second, page number 45.
Not settled in local.
Actually, in Lok Adalat, they were supposed to come, but thing is that the proprietor of that land, he's from Haryana. So he has been given allotment to run that business. But he's operating by engaging one manager over there. But even that manager is also asking money from these villagers, this operator, just for the sake of this settlement of Lok Adalat. Whereas there is no case actually, Lordship, since,
I should notice.
yes,
Hard Mr.
Tikipa.
APA for the petitioner. Hard Mr. Desai, the learned public prosecutor for the state of production for this. Issue notice. No formal notice is required to be sent to the respondent number 1. As because Mr. Seri has accepted notice. Extra copy of the petitions have been provided to him. The petitioner shall take steps for service of notice upon the respondent number 2 by registered postal daily, least after 4 weeks. Till returnable date. The further proceeding of GR case number 68 of 2017, pending in the court of the learned Chief Judicial Magistrate, Capital Complex, UPA, Papumpari, shall remain state.
Lordship, meanwhile, it may be state.
States.
Highly obliged.
Yes.
Yes, Your Lordship. Your Lordship, this petition is filed under Section 439, Red, Section 482 of CRPC, seeking bail in FIR bearing number 0039 dated 5/4/2024, registered under Section 407 and 420 of Indian Penal Act at Naharlagal Police Station, and set aside or modification the bail condition.
Where is the bail order dated 04/07/2024?
It's in page number 439, 82 page number, sir.
84.
Yes, 82, Your Lordship.
82.
Yes, Your Lordship. 82. May I go to? This is an application filed under Section 439 of CRPC by the applicant accused with prayer for granting him a regular bail, who was taken into custody after vacating his interim bail order dated 7/5/2024 in connection with Naharlagan Police Station case. Applicant accused absent. However, learned counsel Ms. J. Jonguje has filed an application praying for exempting appearance of applicant accused on the ground of his ill health. May I read the relevant point only, Your Lordship? Ms. J. Doji, learned PP, is present and has submitted that the accused person has not complied with the terms and condition of the interim bail dated 4/7/24 and hence prayed to cancel the interim bail. The counsel for the complainant has stated that learned counsel for the applicant is contradicting her own statement, as because while moving the instant bail, the accused had stated that since he has already refunded the amount of rupees 6,68,944 through demand draft in the name of MSTT Enterprise, he further assured to process the further loan amount, because of which the condition number 5 was imposed while granting the interim bail to the applicant on 4/7/2024, and that despite being directed to appear personally on the next date, the accused applicant remained absent for 2 consecutive dates on 6/8 and dated 5/9. He thought, yes,
Where is the interim order?
interim order.
77.
Interim order, it is in page number 79, Your Lordship.
79 or 77? 79.
Yes, Your Lordship. 79. 79.
But applicant, to the applicant.
My lord, in this case, the accused is not under custody, my lord.
Yes, Your Lordship.
Therefore, my lord, application under 439 may not be maintainable.
Your Lordship, page number 77, it's
Yes.
page number 77. Yes, Your Lordship. This is an application filed under section 439 of CRC by the applicant surveys with praying for granting him regular bail, who was taken custody after vacating his interim bail order dated 7/5/24 in connection with the so-and-so. Accused appeared has submitted demand draft of 6,68,944 in the name of TT Enterprise and has assured to process remaining demand draft SBI loan so-and-so complaint to Mr. Tagu within short period. Thereafter, learned counsel has prayed to grant bail to accused person with any strict terms and conditions. Since the accused has already funded the amount of 6,68,900 through the demand draft, has assured to process the further loan amount, this court hereby grant interim bail to accused person with following condition. Number one, Your Lordship, that the accused person shall execute a bail bond of rupees 20,000 only with sound surety, preferable central or state government employee or having proper land documents. Number two, that the accused person shall not intimidate any of the witnesses. Number three, that the accused person applicant shall not hamper or tamper with the evidences. Number four, that the accused person shall cooperate and appear before the PS when called for. Number five, the accused shall deposit 50% of the loan amount into the account amount of applicant on or before next date, Your Lordship. So because of this, point number 5, Your Lordship, we have filed one IA before the session judge for modification and alteration, Your Lordship. But here she has cancelled it, dismissed it, the IA. Your Lordship, there are judgment of Supreme Court. It clearly stated that the judges can't play as an agent, Your Lordship. In his bail condition, the session judge imposed that we have to pay the loan amount 50%, which we have already paid 6,68,000, Your Lordship. In this case, there are two heads, Your Lordship. One is on the account of the respondent number 2, and the other one, the money has been received from the KYC scheme, Your Lordship, from the government, in my name, in my firm name.
Initially, he was granted interim bail.
Yes, Your Lordship. In anticipatory, we have filed anticipatory bail. In anticipatory bail, we got a interim. Yes.
Earlier, he was granted interim bail.
Yes, Your Lordship.
Thereafter, his interim bail was cancelled and he was taken into custody.
Yes, Your Lordship.
Then again, he was released on bail.
Yes, Your Lordship. Very next day.
Interim bail.
Yes, Your Lordship.
For 20,000.
Yes, Your Lordship.
So then what happened?
After that, he cancelled, in the last hearing, the Honorable Court cancelled the bail, the interim bail.
Interim bail was cancelled.
Yes, Your Lordship. Stated that he has not complied with the point number 5. That is, the accused shall deposit 50% of the loan amount into the account of complainant or on or before next date. So in that, we have applied filed one IA also for the modification and set aside of the point number 5, Your Lordship. Because we want to return the money, but not to the complainant, but to the reliable source, Your Lordship, from where we have received that amount. Because
Then what happened?
But the Honorable Court cancelled the bail application, Your Lordship. They did not provide us proper details of the party from where we have received the money.
Now, did you file any application before the session judge for modification of this order?
Yes, Your Lordship, we have.
Then what?
It's in
Where is the order?
order. Yes, filed exempting appearance and submitted. And not in the. Who thinks to do it? Your Lordship, it's in page number 81.
51.
Yes, Your Lordship. 81, Your Lordship. This is our IA number 292, Your Lordship. In here, the Honorable Court stated that this is an application has been filed by the applicant accused with prayer for modification of bail order dated 4/7/24 and 6/8/24 for exempting the accused applicant to deposit 50% of the loan amount into the account of complainant as per the condition number 5 of bail order dated so and so. Accused is absent. However, the learned counsel J has filed an application praying for exempting appearance of applicant accused on the ground of his ill. The PP is present and has submitted that the instant application is defective as the learned counsel for the applicant has not invoked the relevant provisions of law in filing the instant application. After hearing the learned counsel and taking into consideration the fact that the instant application is defective, the same is hereby rejected and disposed of. Whereas we have filed under 439 only, Your Lordship, for the modification and set aside and alteration, Your Lordship. We pray for the modification, but it has been dismissed, Your Lordship.
How much amount you have already deposited?
Already 6,68,944, Your Lordship. We have already paid it.
That is, it is less than 50%.
Sorry, sir.
Less than this 50%.
Yes, Your Lordship.
How much would be the 50%?
50% is like 9,97,000, which we have to pay. But from the very beginning, during the anticipatory bail application, Your Lordship, we have stated this honorable court that we prayed this to honorable court that we want to return the money, but in the actual resource, Your Lordship, to the reliable resource, because we have received that amount from the government under the KYC scheme, Your Lordship, and it is in our name. But the complainant wants that amount in his account and wanted to send in different account. So we,
When you will pay the money?
sir, we need at least 2 months, like 2-3 months, because we are also in loss now. Because they don't want to take the machines from us, whereas we have already made the machines. And we are
So,
also facing the loss, Your
I will give you 6 months time
Okay, Your Lordship.
to pay the money.
Okay, Your Lordship. I will.
Hard MS.
J. Jongliju.
You pay for the hard Mr. J. saying. We learn upon the prosecutor for the state and board of secretaries. This is an application under section 482 of the CRPC 1972. Within bracket 580 to 528 of the BNSS 2023. Seeking modification of the order dated 04/07/2024, passed by the learned Sessions Judge UPA, Himachal Pradesh, in PA number 209 of 2024, IN, arising out of NLG PS case number 39 of 2024.
My
The
lord,
petitioner filed such an application before the learned sessions as UPA, praying for modification of that order. And the said petition was not considered by the trial court. Therefore, the present petition has been filed. The learned counsel for the petitioner submits that petitioner has already deposited how much?
Your Lordship.
Already deposited how much?
6,68,944.
And the petitioner needs some more time so that he can
9 lakh कितना था?
pay the entire 50% of the entire 50%
50, yes. Your Lordship.
as directed by the learned sessions judge.
9 lakh कितना था? इसमें?
I have considered the submissions made by the learned counsel from both sides. This court is of the opinion. Where is the rejection order? Page number?
Rejection number for IA, Your Lordship.
Huh?
It's in 81, Your Lordship. Page number 81.
This is the order you are challenging.
Yes, Your Lordship.
This court is of the opinion that the petitioner deserves to be given an opportunity to pay the entire 50% as directed by the section judge. Therefore, the impugned order dated 0509 2024 passed by the Learned Section Judge UPL in I number 292 of
292. Yes, Your Lordship.
292 stroke 2024 dash IN arising out of PA number 209 stroke 2024 dash IN is set aside. Where the petitioner is given 6 months time from today to pay the entire 50%. Thereafter, the trial court shall consider further prayers of the petitioners. Your interim bail cancel.
Yes, Your Lordship.
The petitioner is allowed to remain on interim bail as granted earlier by the Learned Section Judge, UPL, on 04/07/2020. With the aforesaid direction, the present application is now displayed.
Highly obliged, Your Lordship. Fair, my Lordship.
Yes,
My Lordship, this matter is listed day after tomorrow night.
you have to tomorrow.
Yes, I have taken consent.
We take it on Monday.
Monday.
After hearing the Learned Counsels of both sides, the matter is adjourned today. List on next Monday. What will be the date? 16. Yes.
Records were called for the last opinion.
Reports received or not?
Reports must have been received.
Scanned copy of the suit number so and so received. From CJ. Notice out the
Yes, notice, sir, they are not appearing. Madam, it's a very simple case, actually, my lord. Suit was filed before the Learned Civil Judge Senior Division, my lord, for with respect of a particular land. Thereafter, my lord, after taking for a notice being issued, they approached the village authorities. There they have taken a decision. That could not have been done. That is a simple issue. They are not appearing. On one occasion they appeared, thereafter they have not been appearing. Wakalanama is filed. Yes, their names are shown. U, Bodi and T. Lambu. They are just not appearing.
Then I will give them one last chance. If they do not appear on the next date, then I will hear you. Heard Mr. T. Pangi appearing for the petitioners. Non-appearance for the respondents. The scanned copy of the case report has been received. Fair. The court has decided to provide one last opportunity to the respondents to contest this petition. Therefore, the case is adjourned today. When do you want it?
After the week,
Least after a week. It is hereby directed that if on the next date of listing, the respondents do not appear, the petitioners shall be heard alone. Okay. Item number 8. Scanned copy of the LCR receipt. It is a joint application.
My lord, there is joint petition.
What are the sections?
My lord, sections is, my lord, section, my lord, this Foxco, my lord, section 10 of the
10 of
Foxco.
POCSO?
Yes, my lord. My lord,
Where is the FI?
FIR is page number 14,
14.
my lord.
Registry is directed to implead the informant as one of the respondents. Fair. I have also heard MST Gini, the learned additional public prosecutor for the state of Himachal Pradesh. Fair. Call for the LCR. Something. The appeal is admitted for hearing. Call for the LCR. The registry is further directed to appoint one amicus curiae to on behalf of the appellant stroke convict. Fair. On receipt of the LCR, the registry shall prepare the paper book. Copies of the paper book shall be provided to the amicus curiae as well as MST Gini. After that, the case shall be listed again.
Deeply.
Item number 10.
Yes.
My lord, annexure 15 is a impugn order which I have challenged.
My lord, I'm appearing for the sole respondent. My lord, to be very frank, if we go by this, admittedly, it might be hit by the provisions of law. Anyway, my lord, I may be given the opportunity to take make a consultation with my client. Maybe we can fix it on 25th. It is only whether the bouncing of check, the period which is prescribed has been followed or not. That is the only issue. And
What
is this?
is item number 10? Civil religion petition. In fact, this is your lordship, this is a civil revision petition against the impugn order had annexure 50.
Partin is not in this case.
But I'm sorry, I was under the wrong impression.
Lordship, there are two matters. One, item number 7, that has
Yes,
already been
yes.
absorbed.
This is
So
item
we can
number
proceed.
10.
This is item 10.
No, here also Mr. Partin is there. Your name is here.
Yes, yes, Malat, yes. Yeah.
Lordship, annexure 15 is the impugn order. By
15.
yes, page number 71.
71.
Yes, Lordship. By this impugn order, the learned trial court holds that this is the summary suit. Since this is a summary suit and governed by Order 37 of CPC, so I was not given opportunity to defend the suit, and accordingly, the matter was fixed for judgment, Your Lordship.
Summary procedure is applicable
Yes.
here.
No, yes, Lordship.
Huh?
Summary proceeding is not applicable in our rowing code, rowing civil code. Lordship, Order 37 said that code and classes of suit in which the order is to apply. The order
Order
37.
thirty-seven.
37. 253. Page number.
Summary procedure.
Yes, yes, your lordship. This order shall apply to following courts only: High Court, City Civil Court, and Court of Small Causes. Only 3 classes of courts has been designated as the court where summary procedure will apply. And thereafter, lordship, clause B, other courts also. In respect of other courts, there is an explanation provided that in respect of court referred to in clause B, High Court may by notification in the official gazette restrict the operation of this court only to such categories of suit as it deems proper, and may also from time to time, as the circumstances of the case may require, by subsequent notification in the official gazette, further restrict, enlarge, vary the categories of suit to be brought under the operation of this order as deemed fit and proper. So, lordship, the rowing civil code is not the court which is meant by this order 37 of CPC, lordship.
Rowing civil code is not been declared as a.
That is not a civil code, it's city civil code. Also not a high court, and also not court of small causes. 3 categories of court has been described here, where summary procedure applies, specifically applies. So that court is neither high court, nor city civil court, nor court of small causes. Lordship, for the sake of argument, we assume that this court has power to try the suit summary. Now, then, Your Honor, in that, lordship, in that event, there is a procedure which has to be applied by the trial court. Procedure has been, lordship, order 37 rule 1, 2, and thereafter order 3, wherein the procedure after appearance of the defendant has been given. So, procedure for the appearance of defendant. In a suit in which this order applies, the plaintiff shall, together with the summons under order 2, serve on the defendant a copy of plaint, annexure, and defendant may, at any time, within 10 days of service, enter an appearance, either in person or by a pleader, and he shall file in the court an address for service of notices on him. So, as per rule 3, when the defendant appears, he shall file in the court an address for service of notice upon him. So, on receipt of the notice summon, the defendant duly appeared in this case, lordship. Case number 45 is the order dated 27/9/23. By this order,
Okay, Mr. Patil, what is your reply to that?
My lord,
What is your reply?
uh,
He is saying that the court in rowing is not a small causes court.
my,
So summary procedure cannot be applied.
my lord, Arunachal Pradesh Civil Courts Act 2021 is enacted, and another provisions is clearly mentioned that the courts whatsoever civil CPC
Do you have
will.
the book?
Lord, actually, I have not brought my this thing also. My lord, in any case, my lord, the civil judge, civil court, senior division is a court under the provisions of the civil procedure court. Secondly, my lord, may I just hire your. My lord, let us see the impugned order, my lord. Page 71. Now, the second ground is that notices were not issued. And how notices has to be issued, whether, how the addresses has to mention, my lord, my younger friend has taken us through. Now, my lord, let us see this 18/3/2024 order. Mr. Such and such learned counsel for the plaintiff is absent and steps. Mr. D.K. Gupta appears for the defendant. This is a summary should file under such and such. notice was issued on 1/7/23. First, this is first part. On 18/3/2024, counsel for the defendant, the petitioner hearing, he had appeared, Mr. D.K. Gupta. By affidavit corresponding to the petition number such and such filed by the plaintiff, it was confirmed that the defendant received the notice on 15/9/2023. Second part, my lord. The records clearly establishes that on 15/9/2023, the defendant had received the notice. On 27/9/23, Mr. M. Modi appeared for the defendant and submitted that the defendant only received the notice, but it was not accompanied by copies of the plain and documents. The copies of the plain and documents were instantly served. This is the third part, my lord. On 27/9/2023, Mr. M. Modi appeared for the defendant, and it was submitted that the plain documents were not received, although the legal notice was received, and therefore it was instantly handed over. On 6/11/23, Mr. D.K. Gupta, he again appeared. This is the fourth part, my lord. Appeared and filed a WS corresponding to petition number such and such and such as, my lord. The matter was heard on 8/12/23 and was reserved for order. My lord, fifth part has two subpart. One is on 6/11/23, counsel Mr. D.K. Gupta again appeared and filed his WS. And a petition application under order 7 for rejection of the plaint was filed, that was heard, argued, and it was reserved for the judgment. Now, this is again the sixth part. I have heard the respective counsels. This is a summary shoot, and the defendant is required to enter appearance within 10 days of receipt of notice. On default of appearance, the plaintiff is entitled to get a final order granting the relief claim in the suit. In this case, the notice was served to the defendant on 15/9/2023, and the defendant made his appearance after the lapse of 10 days. Therefore, the defendant ought to have in the first place filed a separate application for condonation of delay. Only in the event of condonation of delay by the court, the question of written statement or filing of leave petition to contest the suit arises. Nevertheless, in paragraph 5 of petition number such and such, the defendant has stated that defendant is resident of Bangalore, which is far away from Arunachal Pradesh, and hence there was little delay in filing the petitions and written argument. The ground for delay is not satisfactory. Now, my lord, I pause him, my lord, here. Even the question of delay and requirement of filing the condonation delay petition has been referred to, and in any case, the learned court below has taken cognizance of at least not legally, but then he has taken cognizance of the explanation. That is, but this petition was never a condonation petition under Section 5 of Limitations Act. The ground for is not there. This is because within 10 days, the defendant can easily reach rowing unless he is very sick or there is any other compelling reasons. The defendant has not shown any such sickness or compelling reasons. He has merely stated that Bangalore is far away from Arunachal Pradesh.
The condonation relates to filing of the written statement.
Written statement and the legal requirement is in a summary shoot, after receipt of the notice, he must reply within the period of 10 days. And if he fails to do it within the 10 days, he has to file a condonation petition seeking condonation with delay. In this case, my lord, it is very clear that on 15/9/2023, earlier they have appeared, that also the court has not taken cognizance. Okay, no problem. But the registered post, receipt of the registered post clearly establishes that on 15/9/2023, he has received it. Okay. Learned court below has taken 15/9/23 as the date of receipt of the notice. And from this 15/9/2023, he did not file the written statement for condonation of delay. And if that written statement is not filed, then the court below is duty bound, is mandatorily bound to pass the order. And accordingly, he has given this order. Now, where is the illegality? He had appeared And then in a subsequent date, postal receipt clearly shows that he has received the notice. But within
Where is the provision for filing interest statement?
Yes,
Within
Your
10
Lordship.
days?
Yes, Your Lordship. I'm coming to that point. Lordship, this is the rule 3. I would like to read the rule 3.
Rule 3.
I've already read out the rule 3, Your Lordship. In a suit where this order applies, the plaintiff shall together with someone
Procedure for
under rule 2,
appeals. This is order.
rule 3 of order 37. Specific provision is there.
In a suit.
Serve on the defendant a copy of the plan together therewith, and defendant may at any time within 10 days of such service.
No, from where you are reading?
Rule 3, Lordship.
Rule 3, order 37.
Order 37, rule 3.
Well, this order clearly says that on 15/9 copy was
In this suit,
My lord, let me read it.
you are reading the rule 1.
Rule 3.
Rule 3.
Sub rule 1.
Not directly rule 3.
Huh?
Rule 3.
Procedure for appearance of defendant.
Procedure for appearance of defendant.
Oh.
Rule 3.
Then in a suit,
1, 2, and then 3.
3.
Yes.
Well, order 37 deals with the summary procedure.
Okay.
This is the procedure
On the day.
which applied in
No, on the.
Lordship. We are proceeding on assumption that summary suit applies.
So you read the 3.
In a suit into which order applies, the plaintiff shall together with the summons under rule 2 shall serve upon the defendant a copy of plan. Accordingly, copy of plan was served upon us, Your Lordship.
On
An
50.
extra was also served upon us. We agree. And defendant may at any time within 10 days of such service entered an appearance either in person or by pleader. Accordingly, we entered our appearance, Lordship, in the learned trial court. Thereafter, sub rule 4 says, if the defendant enters an appearance, Lordship, as soon as I entered appearance, the plaintiff shall thereafter serve upon the defendant a summon for judgment. In form number 4A in the appendix P. Yes, Lordship.
In form number 4A.
4A. So it is the duty of the plaintiff to serve a judgment, summon for judgment. But the plaintiff has not served upon us the summon for judgment. Within 10 days, I will appear within 10 days. And thereafter, plaintiff has to serve summon for the judgment in so and so form. Or such order is such form as may be prescribed from time to time. Returnable not less than 10 days from date of service of supported by affidavit verifying the cause of action and amount claimed and stating that in his belief there is no defense in the suit. So plaintiff has to serve also an affidavit. There is no defense to defend the suit. So this part has not been complied by the plaintiff. Thereafter, after waiting for 10 days, again, when the plaintiff failed to comply this provision, we decided to file our WS, Lordship. Then there is a provision that defendant may at any time within 10 days from service of such summon for judgment. So according to rule 5, the defendant may at any time within 10 days from service of such summon for judgment. So when defendant will file the WS or leave petition to defend, when the summons for judgment is served upon us. So plaintiff has not served upon the summon for judgment, Lordship, by affidavit or otherwise, disclosing such facts.
Even then you filed the written suit.
Your Lordship, when they have failed to comply the provision of summary suit, then we decided to contest the suit. Because, Lordship, this suit, summary suit, has lost its nature of remaining summary suit. As because defendant did not comply the provision of summary suit. So we decided to file our WS. Automatically, this suit has changed its nature from summary suit to regular suit.
But the order says something else, is about condonation of delay.
Yes, then we are coming to next para. We are coming to next para of the
Condonation of delay.
condonation. When
comes
the condonation of delay will come into play, once the plaintiff files the summon for judgment, then we shall be given 10 days time to file petition for condonation of delay, to file petition to defend the suit. So unless and until the summon for judgment is served upon us, we cannot file petition for leave to defend the suit. So it was never filed by the plaintiff. Summon for judgment was never filed by the plaintiff. Accordingly, when they failed to file the summon for judgment, we decided to file our WS as well, because we have to complete our part. We are the defendant. We have to follow the procedure. Accordingly, we follow the procedure. But when the plaintiff did not follow the procedure of summary suit, we decided to follow the procedure. Accordingly, we done the same.
My lord, it is the other way around. My lord, on
Your
15/9,
Lordship, may I complete? So When they fail to comply the same, I file the WS. Along with the WS, I also file Order 7 Rule 11 petition. Along with the WS, another petition was also filed to allow us to defend the suit because plaintiff has not completed his part. So I will be allowed to defend the suit. My Order 7 Rule 11 petition was not considered. No order was passed on Order 7 Rule 11. Though there is the suit is specifically barred. It was filed after 3 years from the date of cause of action. Suit was specifically barred. Accordingly, I filed the petition to reject the plan because it is barred by limitation. So my Order 7 Rule 11 petition was not considered. My leave petition to contest the suit was not considered. My WS was not considered. Directly, matter was fixed for judgment. So court has to fix the matter for judgment, but court has to follow the procedure of summary suit here. So entire argument is based on the assumption that summary suit applies. In our case, and that Order 7 Rule 11 petition is still pending, Lordship. It is still not disposed of.
Okay, all right. Yes.
My only one reply is, well, when it is a summary procedure, the first thing is from the date of receipt of the copy of the notice. Now, within 10 days, the defendant must file an application seeking right to defend. And if it is filed within 10 days, the court, which is taking up the matter, has to allow. Then only the next stage of proceedings comes up. Then only the filing of WS. In this case, they have not filed the application seeking right to defend. This is the provisions under Order 4 and 5. And they have straight away filed the WS. There is no mention that the WS was filed after 10 days. The Lordship may kindly again take note that date of receipt of notice has been taken as on 15/9/2023. Now, that is not disputed. They also cannot dispute. Now, whether this mandatory period of 10 days was followed in filing a right to defend, application for right to defend. And then once it is allowed, then they have the right to file their WS. That has not been followed. And therefore, when it is the provisions of law, can we just say that the court below has not followed the procedure prescribed under the summary proceedings? In fact, that is what I'm saying. His submission is other way around. I should be submitting this. Notice was issued long back. Counsel appeared. That also court did not, okay, no problem. But since the copy was not served, maybe. Then on 15/9/2023, it is confirmed that the copy was served. And from 15/9/2023 up to 25/9/2023 was the time. Within 25/9/2023, he ought to have filed an application seeking right to defend. And once it is granted, and it is mandatory, if it is filed within 10 days time, the court below has to allow the application. And once it is allowed, then only the question of filing of WS. Now here, 10 days time has left. He has not filed any right to defend within 10 days time. And there is no condonation, no explanation. Just because he is from Bangalore, that cannot be an explanation. Because Bangalore to from Dibrugarh, there is a direct flight from Dibrugarh to Roing. It is a 2.5 hours drive, my lord. So that cannot be the ground in any case, my lord. He has come for business. He has invested crores and crores of rupees there, coming from Bangalore and doing business. And for the court this thing, he cannot just say that he's from faraway places. So therefore, my lord, my respectful submission is that the order passed and by the learned court below does not suffer from any illegality. And my lord, this is a question of repayment of payment of monetary dues, my lord. And the proceeding is pending before the court. There is a stay order. It is not proceeding further. The Lordship may.
I will
Your Lordship,
have to modify this order.
Your Lordship, page number 14 is very important. Your Lordship, page number 14 is very important. Page number 48, Your Lordship.
Page number 40.
48, yes, Your Lordship. in compliance with Rule 3, Lordship, I have filed my address. Rule 3 says,
Okay, all right, I understand. There also, Art Mr. D.K. Gupta, appearing for the petitioner. Art Mr. T. Patil, the learned counsel appearing for the sole respondent. Fair. The revision petition has been filed. On the Article 227 of the Constitution of India, challenging the order dated 18/03/2024, passed by the learned civil judge senior division Lower Dibang Valley, District, Arunachal Pradesh. What is the case number?
Manisut 2/23.
In Manisut number
2/23.
02 of 2023. Fair. The petitioner is the defendant before the trial. The proceeding was a summary proceeding. Fair. The petitioner, being the defendant, entered appearance and also filed an application under Order 7, Rule 11 of the Code of Civil Procedure, praying for rejection of the plaint. Right. The said the learned trial court rejected the prayer of the petitioner for condonation of delay and posted the case for hearing and judgment.
No, my lord, there was no application for condonation of delay. It was only in the
The prayer for condonation of delay was rejected.
Yes.
Here in the order.
There is a order. Yes.
Well, only in the written statement, only they have just made a reference. There is no separate condonation petition.
Application, but probably the verbal prayer.
No, there was a prayer here. Prayer. I can show the prayer. We have
Well,
also filed a prayer.
There wasn't any separate application
Yes.
under section 5
There is an
of Limitation Act
application. There is an
seeking
application.
condonation.
But
It was all,
here it is written that in view of the above, the prayer of condonation of delay.
no, my lord, it is reflected that it is only in the written statement only that there is a mention. Not in a separate condonation petition, my lord.
Page number 55, Lordship. Page number 55. There is a prayer.
Prayer in the written statement.
Yes, Your Lordship. There is a prayer. That's why the prayer has been reflected in the order.
I have considered the submissions made by the learned counsel. Fair. After going through the impugned order, this court finds that the learned trial court failed to comply with the provision of law as laid down in Order 37, Rule 3, within bracket 4 of the Code of Civil Procedure. Therefore, the impugned order is bad in law. The impugned order is set aside. The case is remanded to the trial court for starting the procedure from the stage of Order 37, Rule 3, within bracket 4 of the Code of Civil Procedure. Fair. It is also directed that before proceeding further with the Manisut, the court shall dispose of the petition under Order 7, Rule 11 of the Code of Civil Procedure. With the appropriate direction, the revision petition stands disposal.
My lord, kindly fix a particular date for appearance of this court bill.
Parties are directed to appear before the trial court on.
Lordship, after Puja, it will be better.
My lord, no, my lord, it is already delayed. My lord, can it be next week?
Will it be possible? Next week will be probably too short.
5 October? 5 October? Sir?
5th October.
5th October.
5th October is Saturday, my lord.
Yes, it's open day.
The open day,
Open day. First Saturday.
working day.
No,
First
no,
Saturday.
no.
There is the first
Oh,
Saturday.
no, my lord. Doesn't function. Registry is open, but the court doesn't function.
Then,
The Lordship, 9
Let
October.
be on 4th
9 October.
4th October.
8 October, 9 October.
No, my lord, it is too late.
4th October, 4th.
Otherwise, I was checking for within this September.
Lordship, we have other matters at QCK also.
Then you appear on 4th. Both the parties are directed to appear before the trial court on 4th of October for receiving further argument. With the aforesaid direction, the revision petition stands displayed.
Obliged, lordship.
I don't know where.
Two kind of person. Last week. 12. Item number 12. Lordship, I have filed this appeal.
You are appellant.
Yes, I am the appellant here. Lordship, may kindly. Actually, Lordship, I was convicted under section 10 of Foxwell.
You statutory appellant.
Yes.
Hard Mr. D.K. Gupta appearing for the appellant. Hard MS T. GD. You learn additional from the prosecutor for the state of order to this. The appeal is admitted for hearing. Issue notice. No formal notice is required to be sent to the respondent number 1. As because MS Gini has accepted notice. Extra copy of the memo of appeal shall be provided to her. The appellant shall take steps for service of notice about the respondent number 2 by registered postage ID. Call for the NCR. List after 4 weeks.
Lordship, date may be fixed. Lordship, it will be convenient to us. Any date may be fixed.
Appeals.
After 4 weeks.
Lordship, we have also filed a IA in this case
For
for suspending the sentence and allowed to go on bail. Because we have a strong, reason for paying.
I also notice will be issued.
We have already served the notice on PP. Okay, has been-
Number 2, Your Lordship. This is the first
given
time
the
even
copy
the
to
IA has
PP.
come up, Lordship.
There is strong, Lordship, there is strong reason. Strong reason. Lordship, kindly have a look on page number 61. Page number 61, 62. Page number, your please, page number 60 is the statement of the warden.
Your Lordship, at
In
this stage, Your Lordship.
Lordship, in this case, in fact,
I just want to see what is there.
page number 60 and 61. In fact, Lordship, the learned special court hold that accused hugged the victim tightly. That was the only observation. And according to witnesses, I have gone through the witnesses here, on the version of the witnesses, the victim told to her parents on the very day, on the first day of occurrence, that the accused only touched the body of the victim. This was the statement by the accused, by the victim, made to her parents. Both the parents were examined in this case, and both the parents deposed before the honorable trial court that only accused touches the body of the victim. That was the only statement.
That is
Lordship.
the offense.
Yes.
Yes, Lordship. Lordship, there are two other witnesses. Warden, hostel warden. Hostel warden says in the court, trial court, that victim was only accused only touches the victim's hand only. This is the version of warden. Only hand was touched. And why hand was touched? Because the accused was about to give guava to the victim in classroom. That is the only allegation. 4 witnesses are there. 4 witnesses says that only body, 2 witnesses says body of the victim was touched, and 2 witnesses said that only hand of the victim was touched by the accused. This is the only version of the witnesses. Even parents of the victim, warden of the victim says.
Those are not
that
the
only body was
eyewitnesses,
touched.
Your Lordship.
And 1 witness says only hand was touched.
You have to wait. Heard Mr. D.K. Gupta appearing for the Applicant, Bart MSTG, the learned additional prosecutor for the state board of service. Issue notice to the respondent number 2. The petitioner shall take steps for service of notice of respondent number 2 by the through the concerned police station. List of the 2 weeks.
Deep.
Item number 13.
Ma'am,
Yes.
my lord, this is a my lord joint petition filed by the my lord four petitioners, my lord, for quashing the FIR, my lord. My lord, this case has arisen out of the completely misunderstanding, my lord.
Oh, what is this? 195A?
195, my lord, is wrongly inserted. This is something, my lord, giving false evidence, my lord. So, my lord, false evidence is something section 3 of the Evidence Act says, my lord. Whatever the statement you made before the court, my lord. Filing of the, even assuming if somebody files a false FIR, my lord, 197, this will not come, my lord. And once 197 goes away, my lord, then for criminal trespass remains, that is a compoundable offense, my lord. So automatically, but this, my lord, facts is something like, I just put on brief, in a very brief note, my lord. My lord, this is something in the last election, General Assembly election, my lord. What happened, this informant, who is the petition number 1 here, he was my polling, he was the polling agent of the candidate from NPP. So just before, like tomorrow, so just while this MLA candidate and one of the petitioner, his sister, they were going towards their village to cast the vote on the next day. So they just wanted to visit, they wanted to make a courtesy visit to this petitioner number 1, who is the informant in this case. They went there, and when they inquired, then his doctor informed that his father had been kidnapped by some other 5 person. They came with mask thing and they took their father. Then, Your Honor, my lord, then immediately what this MLA candidate, who is not the petitioner here, MLA candidate did is that he immediately informed to the deputy commissioner, my lord, because safety of the polling agent is very important. He immediately informed to the deputy commissioner and and to the petitioner number, my lord, will see that the petitioner number 2, he was the election agent of the NPP candidate, my lord. Petition number 2. He was not there at the place of appearance, my lord. He was not in that house. He was at Palin, my lord. Then the MLA candidate telephonically called him, saying, you lodge one FIR. You see, our polling agent had been kidnapped, like this. Then, my lord, this petition number 2, he lodged an FIR to the police station, my lord, saying that the informant, who is the informant here, petitioner number 1, he had been kidnapped by some other person for his safety, my lord, because there is an experience on last time also, in last general election also, my lord, he was kidnapped, my lord. So this time also what happened, my lord, this petition number 1, the informant in the case, he protested against the BJP candidate. And because of his protest, certain deletion of the electoral names took place, my lord. So there was a threat perception that he might have been kidnapped by the rival party, my lord. That's why, my lord, petitioner number 2 lodged the FIR at the instruction of his MLA candidate. My lord will kindly turn to page number 16, my lord. Not 16, my lord. I will come to page number first, my lord. 18, my lord. Then I will come to 16, my lord. Page number 18, my lord.
Yes.
This is a type copy. May I read, my lord?
Yes.
That, sir, it is to bring to your immediate attention that one Sri Biki Tamo, who was appointed as polling agent at Rai Bolo from NPP party, has been kidnapped by a group of 5 persons wearing masks from his residence at her helipad ground, Pania, today at around 8 p.m. on dated so-and-so. We have a reasonable apprehension that our polling agent may be kidnapped and abducted by the workers and team of Balo Raja because previously he had lodged complaint regarding the bogus voter at Rai Bolo police station, resulting deletion of the number of the team Balo Raja voters. The kidnapper also lifted the victim by bearing registration number. Further, it is pertinent to electoral procedure. Therefore, we humbly request your good office to stop the electoral process so-and-so by petition number 2. This FIR was lodged by the petitioner number 2, my lord, saying that the, my lord, Biki Tamo, who is the petition number 1, he had been kidnapped. Kindly take the action. Thereafter, what happened, my lord? This petition number 1, after few days, he lodges complaint against petition number 2 saying that you lodged false FIR telling about my abduction, kidnapping, whereas I was not abducted. My lord, may I come to page number 16? This FIR I am seeking for quashing, my lord, page number 16.
Or you want this to be quashed?
Yes, 16 to be quashed, madam. Well, page number 16, madam. Now he is writing this. Vicky Tamo, he is the petitioner number 1 here in madam. Now he is writing. I have the honor to inform you that on so and so an FIR was lodged by one Sri Khoda Vijay, election agent of NPP candidate, wherein a narrative of kidnapping upon me was fabricated by him. Afterward, a viral video of my daughter was recorded by one unknown lady who was approached by a Toyota for white collar, and the video was uploaded in social media on our absence, where my daughter was forced to give a fabricated story of my abduction by 5 persons from my residence located at Pania, but on the same day I went to so-and-so. In this regard, I request your good office to register a criminal case against the unknown lady who is supposed to be an associate of NPP candidate and book her under appropriate section, madam. Basically, this Vicky Tamo is the petition number 1. He is saying that this unknown lady has recorded the video. Then, my lords, after that, they sat together. That because my lord, see what are the sections registered, my lord? Section 195A, my lord. My lord, this section is applicable only when the somebody is forced to give the false evidence. Now, my lord, filing FIR cannot be said as evidence. So that's why, my lord, this 195A is not, there is no ingredients of 195A. So for this case, now, my lord, 447 is a criminal trespass, man. House trespass, a criminal trespass, man. Only 3 months punishment, man. Then, my lord, 506, then 447, 506, these are compoundable case, man. Now, only the section is 195A, man. Now, my lord, after that, my lord, we had a meeting together, man. Then this misunderstanding has been cleared, man. My lord, kindly turn to agreement, my lord, page number 19, man. Page number 19, till, my lord, page number 25, man. So, then, my lord, in the meeting, it was made clear that the daughter, the minor daughter, she was under the wrong impression that because 5 persons came, so she was from the other party. So she was under the impression, wrong impression that her father had been kidnapped. That's why she reported the matter. And as reported by the daughter, my lord, for his safety only, we lost the FIR, my lord. So this is how we have solved amicably, my lord. So this is the case, my lord. Basically, once 195A goes away, my lord, nothing remains, my lord. This may be allowed, my lord, this quashing, my lord. This is joint petition.
Yes, your lordship. Your lordship, otherwise I don't have any objection to quashing of this petition because it seems there was a misunderstanding because there are counter FIRs. Also, your lordship, my only query was who was this unknown lady, your lordship, because none of the complainant nor his daughter could name the unknown lady. However, I have gone through the case diary, your lordship. Notice under 41A was issued to the petitioner number 3, who seems to be this unknown lady. Otherwise, I don't have any objection.
Quashed.
Well, no problem.
Please, my lord. My lord, this is also a joint petition, my lord, for quashing of the GR 29 of 20 pending before the Chief Judicial Magistrate, Dapurijam. But this is regarding a theft, my lord. That was.
Where is that?
FIR is at, my lord, page 22, my lord. It starts from 19, my lord. In fact, my lord,
Please read the FIR.
with due before that, my lord, may I take your lordship to page 14, my lord. This FIR came later, my lord, because this is a case of an underprivileged boy, my lord. He was working as a laborer on the house of the mother of the informant, my lord. There he stole 2 local bangles, 2,000 rupees and 1 Philips radio, my lord. And
Page number 14, what is this?
14 is the settlement. Immediately after that, my lord, he took the radio and 2,000 rupees and ran away, my lord. Now he was caught and then this settlement was done, my lord.
What was stolen?
2 local Bengals and, my lord, 2,000 rupees and 1 Philips radio, my lord. And out of the 2,000 also 1,500 was recovered, my lord. And the local Bengals was also returned back, my lord. This is the kabam. Initially, it was in the year 2019, my lord. 9th of November 2019, that kabam was held, my lord. So in that kabam, my lord, translated portion, not translated, my lord, typed copy, if you also will see at page 17, my lord. This happened before the lodging of the FIR, my lord.
Or before the lodging of the.
Yes, my lord.
The
The settlement itself was done, my lord.
Who was the FIR?
Page 17, if your lordship would come, is the type copy, my lord. 17, my lord, page.
Who is the informant here?
Informant is the son of the victim, my lord.
Son of the victim.
Yes, my lord. Now, my lord, in that cover, my lord, held in 2019, my lord. It was,
You please read the FIR.
yes, my lord. FIR against so and so, my lord. Sir, with due most respectfully, I beg to inform you that Sri Tachumagria so and so, son of so and so, under so and so of Upper Sulawesi district so and so, and dated 30 October 2019, come to my village down as labor and stole my mother's Philips radio, local beads, some local ornaments in the same day around 6 a.m. Later on well inquiry, he himself confessed that he take all that lost property and assured to return back the same very soon. But yet he failed to do so. And secondly, after inquiry from his family and his relatives, this is found that he is a habitual offender. So in this regard, I, on behalf of my old mother, do here highly request to arrest the person as soon as possible and recovery the lost items to ensure justice to helpless widow on the humanity ground. This is the FIR. Otherwise, what happened, my lord?
Oh, who is this petitioner number 1?
Petitioner number 1 is the accused person.
Who is the accused? And who is the petitioner number 2?
Petitioner number 2 is the informant, man.
Yagnia Don.
Yes, man. And petition number 3 is the mother of victim, my lord.
Mother of the.
Informant, my lord, who is the victim, my lord.
From her, those things were stolen.
My lord.
But Keba was held on what date?
2019, my lord. But in the Kaba, it was said that the accused person should pay a fine of 40,000, my lord. But since he's a laborer, my lord, he could not pay the fine, my lord. And that because of that only, my lord, in the year 2020, that FIR was lost, my lord. And before, in the court also.
Yes, again.
Lordship, as per the allegation, section is 380, Lordship. Section is 380, theft, Lordship. And as per the Lordship, their settlement, they have already, Lordship, the things, Lordship, that is ornaments that they have returned, Lordship. So if they have mutually settled, Lordship, it can be, Lordship.
First.
Deeply over.
Like.
Item number 15. Yes.
May I please, Lordship? Lordship, this is a regular bail application filed by the applicant, who is the wife of the accused person, for granting of bail to the alleged accused person. To the alleged accused person, Sri Dare Tajam, who has been arrested on.
Again, have you received the diary?
Lordship, we have, Lordship, had the instruction that, or you have this report that it is already been charged sheeted, Lordship.
Already charged?
Yes, Lordship. So we
If
could
it is
not
charged sheeted,
produce
first of all, you go
case
to the
diary
trial
today.
court.
Lordship,
If it is succeeded, yes, succeeded, you go to the trial court. If the trial court refuses your bail, then you come again.
Lordship, during the course of investigation, we have approached before the learned trial court.
The investigation is a different matter.
Okay, Lordship.
After finding of the succeeded, so a different matter.
Lordship.
Hard Mr.
Titaba.
Appearing for the petitioner, Hard MS Hage, the learned petitioner of the prosecutor for the state of ownership to this. This is an application under section 483 of BNSS 2023, praying for granting bail to the petitioner who was arrested in connection with Chimpu PS case number 38 of 2024.
Lordship.
Fair. MS Hage submits that police has filed the charge sheet in this case. MS Hage has submitted a photocopy of the message sent to her by the officer in charge, Chimpu Police Station. The same photostat copy of the information shall form a part of the record. Fair. Since charge sheet has been filed, the petitioner is directed to approach the trial court for seeking regular bail. The petitioner shall be at liberty to approach this court again, if advised. In the appropriate direction, the present bail application stands closed and disposed.
Deeply obliged.
Lordship, I've received the case diary. On the last occasion, the accused was directed to appear before the IO and record his statement. However, your Lordship, as per the case diary, he has not appeared as on that, your Lordship.
Did you appear?
Lordship, I have contacted to this OC police station that Balijan, but I am told that the IO is busy. That is why.
Okay, send the case day again for updating the same.
Yes, your Lordship. Give him a last chance, your Lordship. At least he should appear, even if they do not record this statement.
Heard Mr. T. Tapak appearing for the petitioner. Heard Mr. T. Ete Dinali, the petitioner from the prosecutor for the state of election to this. Fair. At the time of granting interim bail, the petitioner was directed to appear before the investigating officer. Mr. Ete submits that the case diary does not show that the petitioner had ever appeared before the investigating officer. Fair. I have considered the submissions made by the learned counsels on both sides. The petitioner is directed to appear before the investigating officer within next 10 days from today, without fail. Therefore, the CD shall be returned for updating the same. List again on. After Puja vacation, you will do it.
Okay, your Lordship. Then on 22nd, your Lordship.
On 22nd June.
Yes. Your 22nd October.
22nd October. Till then, the interim order passed and is completed.
Deeply obliged.
Item number 17.
Your Lordship, it's a appeal against acquittal and the notice has been issued. However, your Lordship, the service upon respond number 3 and 5 is still awaited, your Lordship. So
3 and
await,
5.
yeah, 3 and 5. Await for the service report, your Lordship.
Heard Mr. T. Ete. He learned an additional public prosecutor. Appearing for appellant. Since the office note dated 1309, since the office note dated 09/09/2023. Await for the service report in respective respondents 3 and 5. List up to 4 weeks.
Deeply obliged, your Lordship.
With the appellant. 482.
My Lordship.
Yes.
In this matter, the previous council has issued a notice to the petitioner.
Huh?
No objections are to be made.
What notes?
And we have newly engaged.
Oh, okay. You are newly engaged. Have you filed Wakalatnama?
Yes, we have filed our Wakalatnama
You need time.
in the meantime.
Hard, Mr.
T. Rolling.
Appearing for the petitioner. RMS L. Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. The learned counsel for the petitioner submits that he has been newly engaged in this case and therefore he needs some time to go through the record. And after hearing both sides, the prayer of the learned counsel for the petitioner is allowed, least after 3 weeks. Is there any interim order pending?
No, Lordship, no interim order. No, Lordship.
Lordship,
Like,
Lordship, meanwhile, I may take press step upon respondent number 2. Through
First of all, you go to the record, then come.
like,
Please, Your Lordship. Your Lordship, I am for the respondent, Your Lordship. Your Lordship, with the consent of the other parties, the petitioner, this matter may be fixed on November 15. As the
On
conducting
request of the learned counsel, Mr.
E. Payang, Your Lordship.
E. Pine, appearing for the respondent.
Yes, respondent.
Case stands adjourned today. When do you want it?
November 15.
15th
My
of
Lordship.
November.
Lordship, meanwhile, interim was here.
You need the earlier order, the interim order passed will continue.
Deeply applied.
Item number 21.
His Lordship, Your Lordship, in the last occasion, Your Lordship passed an direction, my lord, directing the petitioner to approach the learned session court because in appellate court, my lord, regarding the settlement between the parties, my lord. The petitioner has approached the learned session court and the learned session court has, my lord, kept the matter pending, my lord. So, I think, my lord, we have to file an affidavit regarding showing the status of that case, my lord, as of now.
Have you filed?
My lord,
Have you filed?
we have already approached, my lord, regarding that last order, my lord, we have to,
No, where is the order? Last
Lordship,
order?
Lordship, to record the statement, my lordship, that order was passed.
Wait.
My lord,
What is the date of the order?
I think
my lord, to
25,
14/5, my lordship, 14/5,
25, 8,
No.
25, 8.
14/5.
25/8. 25/07.
507, Lordship.
07.
Yes, Lordship.
Yeah. Record settlement agreement before appellate court.
Have you appeared before the sessions court?
Yes, lordship.
Your statements are recorded.
Yes, we have, the learned session court asked us to file the statement in the affidavit form. My lord. We have already filed it.
The case is not yet disposed of.
No.
So I will fix a time frame. I will fix a time frame within that period. The trial court shall dispose of the case.
Yes.
Art, Mr. Peter. Paying for the petition. Adivasi Al-Hadi, the learned edition from the Prosecutor for the State of Justice. Para. Oh, you were convicted.
My lord,
You were convicted.
yes, 3 years imprisonment, my lord.
Conviction cannot be changed by the trial court. Once he is convicted, or convicted by the magistrate court.
Yes,
Okay, all right.
It's
You
an,
filed an appeal.
yes,
And again, for the learned edition from the Prosecutor for the State of Justice. Para. The petitioners filed this application under section 482 of the CRPC, praying for setting aside the judgment and conviction order dated 14/12/2023, passed by the Learned Chief Judicial Magistrate SEPA, East Kameng District, in GR case number 21 of 2023. Para. On 25/07/2024, this court directed both sides to appear before the Appellate Court of Sessions Judge Bondila, West Kameng District, to have their statements recorded by the Sessions Judge regarding the settlement deed dated 27/02/2024. So accordingly, both sides appeared before the Appellate Court of Sessions Judge Bondila and got their statements recorded.
In affidavit form.
In affidavit form.
Yes.
Stop. Mr. Kapoor submits. Fair. Mr. Kapoor submits that no further order has been passed by the appellate court till now. Fair. I have considered the submissions made by the learned counsels of both sides. Of both sides. Fair. The
My lord, I'm sorry, my lord, I have to inform, my lord, order has been passed by the learned session court, my lord, saying that, my lord, he cannot take up the matter because the matter is sub judice before this honorable court.
the learned trial court, the learned appellate court of Sessions Judge Bondila is directed to dispose of the appeal. What is the number of the appeal?
My lord, appeal we have annexed, lordship. I'll just. It's appeal number 01 of 24.
Yes, the learned appellate court of Sessions Judge Bondila is directed to dispose of the criminal appeal number 01 of 2024 within next 3 months. In dispose of the appeal within next 3 months in view of the statements given by the parties.
Yes.
As directed by this court.
Yes.
With the aforesaid direction, the criminal petition stands disposed of.
Obliged.
Yes.
Lordship, from me. Lordship, in this regard, the service upon respondent number 1 is awaited, Lordship. Respondent number 2. But Lordship, we have a small prayer, Lordship, it can be considered, Lordship. Lordship, going from the records and also considering that the LCR have been received, Lordship. Lordship, from the FIR itself and the Act, the Arunachal Excise Act, it's apparent that Lordship and FIR could not have been lodged by the respondent number 2, Lordship.
Can you appear for the respondent number 2? Excise Inspector.
Your Lordship, I'm not been authorized, Your Lordship.
Is there any counsel for Excise Department?
No counsel is there, Your Lordship, for Excise Department.
No counsel.
And so far as Your Lordship FIR is concerned, it will be always considered as an individual informant, Your Lordship.
Because Lordship, even if the respondent number 2 do come, Lordship, they cannot change anything, state anything that is contrary to the record, Lordship. The record is there.
You take fresh steps. Hard, Mr.
Jeeta, Lordship, there is a small prayer then in regard of.
Preparing for the petitioner. Hard, Mr. T. at the Lale petitioner for the prosecutor for the state of Bonus Parties. The petitioner is directed to take fresh steps for service of notice upon the respondent number 2. By through the concerned
Yes, Your
police
Lordship.
station.
Yes, Your Lordship.
The petitioner shall take steps accordingly. List after 4 weeks.
Lordship, can it be, Lordship, 1 week, Lordship? Lordship, my shop is closed for the past 4 months, Lordship.
It will not return so early.
2 weeks, Lordship, at least, Lordship.
It will list after 3 weeks.
Yes, sir. Deeply obliged.
Much obliged.
May I pray, Your Lordship? This is for quashing of FIR and enter criminal trial for court below. Sections implicated are 354 and 447, Your Lordship. Here the petitioner accused is the petitioner number 1, victim is petitioner number 2, and the informant is petitioner number 3.
Where is the FIR?
FIR in page 19, that is type copy. This FIR is actually, Your Lordship, very much exaggerated one, because after receiving this FIR, many sections were booked. These sections are 376, clause 1, 511, 447, 427 of IPC. But Your Lordship, at the time of framing of charges, many sections were dropped. And lastly, the charge were framed under section 354 and 447. And now the case is under Chief Judicial Magistrate, UPI. The fact is that, Your Lordship, especially this victim number 2 used to sell local wine. So the accused frequently used to visit her house. So in state of intoxication, whatever might have been happened at that night, that is not sure. However, Your Lordship, the matter has been amicably settled because this is the case of 2017. So entire these many years, they could not meet any settlement. However, in the year 2024, the amicable settlement was made. That is on last para, that is an annexure D, Your Lordship, page 27. This is the agreement that has been executed on 11th day of May 2024. Your Lordship, there is a allegation.
What to say?
Your Lordship, on the last occasion, the only objection made was that they have not neither authorized or filed a separate affidavit, which they have filed by an additional affidavit, Your Lordship. So I don't have any issue if the matter is being quashed, Your Lordship, because though there was an section for rape, Your Lordship, which was also during framing of charge, Your Lordship dropped. Now only section is.
The other 2 persons have to file this.
No, that has been filed, Your Lordship.
Additional affidavit.
Additional affidavit has been filed.
Where is the additional affidavit?
That should be there because at the very first hearing, the matter did not, it was not taken up. Only due to non-filing of additional affidavit. Later on, it was filed. Additional 2 affidavit.
Who's first?
Obliged.
Yes, what is
Yeah.
the
Item number 24, my lord, it's an application for condonation of
now
delay.
notice in book?
Yes, ma'am.
Heard, Mr.
R.N. Sungan.
Appearing for the applicant, issue notice to the sole respondent. How do you send the notice? By registered post?
I may be allowed to take through Dusty mode.
By Dusty?
Dusty.
Heard so and so appearing for the applicant, issue notice to the sole respondent. Petitioner shall take steps to service of notice upon the sole respondent by Dusty. List after 4 weeks.
Please, Your Lordship.
What are these matters?
My lord, these are the Holongi Airport land acquisition, my lord. The land was acquired without there being any award, my lord. Therefore, we are before lordships. My lord, affidavits are yet to be filed. These all three pertain to the same different petitioners.
My lord, will be recurrence of more time, my lord, because 3 petitions are there, my lord. They have filed phase-wise basis matter, so my lord will be recurrence of more time to file affidavit, my lord. So, yes, my lord. So we have taken a consent decision. My lord. Can this matter be listed on 4th November? Will do?
If it is not inconvenient for
Lordship. my lord.
When?
4th November, my lord.
4th November.
Yes, my lord.
Heard Mr. P.G. Nayas, appearing for the petitioner. Heard Mr. R.H. Navam, United Additional Advocate General of State of Ownership for this. Mr. Navam prays for some time to find the affidavit. Reply.
Affidavit in opposition, my lord.
Affidavit in opposition. After hearing both sides, the prayer is allowed. List on
4th November.
4th November.
Deeply obliged.
Deeply. All the items. Well, 1, 2, 3, 4, 5. Huh? 31.
31 to 30. Oh, 31, they are tagged together.
31, the same one. Yes.
May please your lordship, this is in connection with a writ petition, your lordship. Your cancellation of transfer order was challenged, your lordship.
Interim prayer was made.
Interim prayer was made in the main writ petition, your lordship. But when it came up for motion on 28th of August, your lordship, that interim prayer was not decided. Hence, this interlocutory application has been filed, your lordship.
Yes. Do you have anything to say?
We haven't received our instructions yet, Manju. So on next date, this interim may be considered, Manju.
Your lordship, it's a transfer matter, your lordship. I have to join the duty until next date at least.
You have to wait. You have to wait. Hard Mr.
And Sharma, your lordship. And Sharma.
M. Sharma.
Yes.
Appearing for the applicant. Hard MS. You are a government. Yes. Dealer government pocket. MS so and so. Submits that she needs some time to take instructions. You take a short date. Her prayer is allowed. Well, you suggest a short date.
After a week.
Huh?
After a week.
After a week. Then you have the calendar, Sharma.
Yes, sir.
Do you have the calendar there?
I don't have your lordship.
Okay. So today, what is the date? 10.
Today it's 10.
Next 17? List on 17 September.
Deeply obliged.
Division.
My lord.
May please, madam. Just a minute. Who are appearing for the respondents 2, 3? Pada is for 2. So you are appearing for 1 and 2.
One.
That's why I say what is 2, 1 and 2. You are for 2, 3. So Sudha,
My lord,
I will take it up on some other day.
my lord. My lord, there is some urgency. Why, my lord? Then, my lord, may I ask for a fixed date? Because, my lord, trial is going to be concluded.
Okay.
My lord, may I pray, my lord, 23 of this month itself?
After hearing the learned counsels of both sides, the hearing is adjourned today, list on 23rd September.
Deeply
for
honored.
hearing.
Item number 29.
Tapak,
Yes, Lord.
I will take it up on some other day.
This application is Lordship, revision has been filed because the ingredients under 226 has not been made out by the court. Neither by the police.
Who is for the respondent number 2?
Respondent number 2 is
Notice served or not?
this Jawang Tesia, victim.
Huh?
Jawang Tesia,
But
victim.
service report. Respondent number 2, no service report. Service upon respondent number 2 is not yet complete.
Not completed.
Not yet complete. You have
Yes.
to take phase steps. Ask Mr. Kitapak, if any for the petitioner. Ask Mr. L. Hagedila, the additional public prosecutor for the state of Arunachal Pradesh. The petitioner is directed to take fresh steps for service of notice about the respondent number 2 through the concerned police station. The petitioner shall take steps accordingly. Least after 4 weeks.
Item number 30.
Yes.
May Lordship, please. This person is filed.
Okay, Mr. Patil.
Yes.
I will take it up on some other day. Some other day. Hard to learn the senior counsel, Mr. M. Patil, assisted by
MUA.
Hard MST Gini. He learned additional public prosecutor for the state of Arunachal Pradesh. The hearing is adjourned accordingly. Adjourned today. List on. When do you want it?
This week.
Next week.
No, this week.
Huh?
This week.
This week, not possible. We have only few days left. So if you want, I will give you next week.
Yeah.
Next week.
Next week. Your Lordship.
18,
At
list on 18
Yeah.
for hearing.
No, 18, Your Lordship, I won't be there on 18. If Your Lordship, without giving any dates, fix this matter after 2 weeks, it would be much more convenient, Your Lordship.
She will not be available on 18th.
Okay.
Then 25,
Yes, sir.
25 September for hearing.
25 9.